This is Bobby Fazy, president of Insight Law. We've got a good crowd today. We are going to be talking about the Secure Act 2.0 and how it impacts retirement plans, IRAs. A lot of our clients have IRAs, and the Secure Act 2.0 was passed in December of last year. And there's been some regulations promulgated by the Treasury, and I've trying to decipher all these new rules for our clients and make it palatable. And the heading here says impacts on planning and settlement. And I'm an instructor for the National Network of Estate Planning Attorneys. That's what's NEPA Fall Collegium. We went in the fall, and us estate planning geeks got together and we're talking about this. So I'm giving you the latest and greatest as far as what the rules are today. This is more of a technical dive into the planning. I'm going to try to be as clear as I can for you to make sense of these IRS regulations. It is our first time, so for the good side of things, you are on the cutting edge and you're learning what the latest laws are, but you also are getting it first. So bear with me as we go through this. This is going to have a rhythm to this when it comes to dealing with the retirement plan rules. So I was thinking about how to, I wrote the outline, how to present it. And I think the first way to present it, and if you have questions, I apologize. If you have questions, I've muted everybody because there's some material to go through. Type the question in the chat and I'll answer it. I promise. If I don't answer it today, I'll follow up and answer it. But my goal is to educate you. IRAs are very important for our clients and how you have your options for it. And so let me start with the basic minimum distribution rules that are out there. And these distribution rules are dealing with retirement plans and IRAs. Specifically when we're dealing with IRAs, our clients have saved for retirement. And the old rules, before we had all the Secure Act and things like that, you just got to get comfortable with the rules. The way it works, think about your IRA as an envelope, right? And I write IRA typically on it. Say this is your IRA, and you put money in all during your lifetime to save for retirement. And there are some rules with regard to it. There's a penalty if you take the money out too soon. They want you to save the money for retirement, and there's penalties for taking it too late. So this is your own IRA, and on your own IRA, there's going to be a point where you have to start taking the distributions. And currently it's age 73, and we'll get into that. And when you start taking distributions out, okay, then you are on what's called the uniform table. I say blue, yellow, green. I say blue, uniform table. It's true blue. You can count on it. And the uniform table has been updated, okay? And so for your IRAs, we had these uniform tables. These are actuarial tables that the IRS uses. Let's make sure that I'm sharing that screen, okay, that the IRS uses. They say, hey, a 72 or 73-year-old has a life expectancy of 26.5 years. Then they would have to take the account balance from December 31st of the year before and divide it. And that's what your required minimum distribution is. And every year you go back to this this table. I just colored it blue right there, right? The names, right? It's true blue. You can count on it. You go back to it every year. If you're 74, you use the 25.5% divisor. And when you take the money out of your IRA, right, that's when you get taxed on it. You get a 1099-R, and that's when you get taxed on whatever you take out of it. And that's why people want to try to a lot of people, if you don't need your IRA, want to delay that because it adds your tax to your tax deal. So that's the idea while during your lifetime and most people get that part of it, and that that hasn't really changed too much from the Secure Act, other than the ages when you have to start taking them, which I will definitely get into detail. Okay, then I'm going to skip to the green. Let's say you pass away, and then when you die, that blue table goes away. Okay, and let's just keep it real simple, and you leave it to a child, that IRA. So they don't get to use under the old laws, they and the new laws, they don't get to use that blue table, which is called the Uniform Life Table. I didn't come up with that. They use what's called the Single Life Table to take their distributions. Under the old law, what you had to do was there's a Single Life Table, and so my daughter is 7 years old. If I died and left my IRA to her, okay, then the IRS says she has a life expectancy factor of 77.9 years. And under the old rule, she would have to start taking, and that was a great estate planning technique, because that means out of that IRA balance, right? If I had $1 million IRA, the divisor, what goes in there is 77.9, okay? And you just saw those divisors for 76, 70-year-olders, like 24, 25, right? So you don't have to take as much from the IRA. And so estate planners came up with all these great schemes where we would leave IRAs to grandkids and the like if that met the goals. And that would just allow compounding for years in these IRAs, right? And so that's how it worked. You go to the Single Life Table at 77.9, and you'd only go to that Single Life Table once. It's a one and done thing. And then every year after that, the next year, NAVA would have to take whatever the December 31st balance and divide it by 76.9, and then 75.9. 74. It's like kind of mission control, 10, 9, 8. You just go back, you go to the table once, and then you just subtract each year. And that's how it worked in the how it typically worked before all the Secure Act stuff went on. So those are blue, and then the green is after you die. Yellow, we're going to talk about when we get to the trust. That's where, if we do designate a trust as beneficiary, how does that work? I'm not going to get into that just yet. Okay, so I got a basic idea of the IRAs. You got to start taking them at certain ages. And the key term that the IRS uses is what's called your required beginning date. Okay, and that has changed from the Secure Act 2.0. Your required beginning date used to be 70 and a half. You see how I crossed that out. Now it's age 73 is when you have to start taking. That's the age where you have to take distributions. But if you turn 73 this year, right, it's April 1st of the year following the year that you do. So you'd have to take your first distribution by April 1st of next year. That's your required beginning date. Okay, that's an important term in the Secure Act 2.0, and we'll show you that. Okay, and so a lot of people will not wait till the next year to take their distribution. They'll take their first distribution at age 73, because if you wait till April 1st of next year, you don't get a pass for next year. You still got to take another distribution for next year, and it bunches, and it might bump up your income. Okay, that's a specific, that's a strategy decision on that, but that's typically people will go out. So this new act, I just threw this in here just to show you, Congress, what are they writing, right? And I try to read this phrase. This is in the actual Secure Act code. I try to read it so many times. I was like, this doesn't make sense. And actually, some smarter people than me, there's this big organization called ACTEC, a bunch of tax attorneys, right? And they were looking at the clause, and they say, look, this is talking about another key concept called an applicable age. Okay, so required beginning date is the date, April 1st of the year you turn your applicable age, okay, which is 73. And they're defining that they're actually, and if I have a little asterisk here, this is a new part to the slide. In 2033, the Secure Act actually moves up your applicable age to age 75. And that's what this code section is trying to say. But these attorneys were like, you know what? Someone born in 1959 actually fits into both categories. Okay, so Congress is going to fix that. They send them, and the applicable age, the one I gave you here, this is what it's going to be as long as everyone, Congress rubber stamps, what they ask. So if you're born before July 1st, 1949, right? Then you're under the old rules. That's under your applicable age is 70 and a half. If you're born between 1949 and 1950, age 72, 1951 to 1959, age 73 is your applicable age, and 1960 or later, then you're at 75. Okay, that's the rule. That's where we're at. All right. So like I told you before, if you take the money too soon, right, then Congress will say, this was for retirement money. We're going to penalize you. If you take it before 59 and a half, that money, there's going to be a 10% penalty, and you're going to have to pay the ordinary income tax on it. Okay. If you take it too late, right? If you don't take it by your required beginning date, it used to be an onerous excise tax. Okay. It was a 50% tax. The Secure Act 2.0 changed that and said, we're going to reduce that to 25% and 10% if it's corrected within 2 years. So that's a nice little thing that they have there. Now, I'm an estate planning attorney, so I look at it when people pass away, do we have the right, beneficiaries designated and the like? And so when someone passes away, there's certain dates that are important from the estate planning side, and we call them the D dates. And so let me see where I put my D dates. My D dates are right here. Okay, so the dates that I look at, I have a little piece of paper that shows the deadlines, right? These are important, is the determination date. So what happens is the year after someone passes away, that's for the IRS. They look at it. You take a snapshot of the IRA beneficiary designations, and that's kind of like whatever those beneficiaries are, the September 30th of the year after the owner's death, that's what we're going with for distributions for the beneficiary. So that's important because there's things we do from my side to clean up stuff or fix, people didn't plan things right, that maybe we can, between the date that someone dies and the determination date, that we may want to get things kind of in order. We do maybe disclaimers, we may divide, a lot of times I want to divide the IRA. And so those things are things that I look at, okay? But that's what the key date is for when there's a beneficiary. They're going to look at how quickly does a beneficiary have to pay out that IRA, under what rules. They're going to take that snapshot as of that date. All right, so that's kind of like the history and some of the basics. Now, here's where the Secure Act 2.0, there's some nuances there. So before the Secure Act, we only had two categories of beneficiaries: a non-designated beneficiary and a designated beneficiary. That was it, okay? Now the Secure Act 2.0 puts in what's called an eligible designated beneficiary, and that's what we're going to look at and how that works. So we're talking beneficiary designations, right? And the real key handout that I gave you, and we'll start with not designating a beneficiary. That's not a good situation usually, okay? Because if you didn't designate the beneficiary, the IRS is going to slam you typically, okay? There's one unique situation where I'll show you that. So the key handout that I use is another one that's kind of that's put on my, laminated on the side of what I have, is called this retirement plan quadrant. Okay, I want to make sure you guys are seeing this, and this is kind of like a very easy reference for me. All right, and so we'll talk about eligible designated beneficiaries, but this quadrant basically says, if you are a designated beneficiary and you die and you die before your required beginning date, that's the rule. We'll look at that. If you're a designated beneficiary and the person died after the required beginning date, that's the rule. Okay. If you are not a designated beneficiary, right, and the participant died before the required beginning date, right, then it's a 5-year rule, right? Remember we showed you all those divisors and longer, time expect. 5 years, and what that means is that if you just forgot to list a beneficiary on your IRA, right, or improperly designated, and the custodian says you didn't designate a beneficiary, that beneficiary has to take all of that IRA out if that participant died before their required beginning date, right, within 5 years, okay, of the date of death, December 31st of the year of date of death. So they got 5 years to clean it out. They don't have to take it out each year, and we'll talk about that. They just got to take it out by the end of the 5th year, right? That's non-designated beneficiary, and the participant dies before the required beginning date. Now, let's say someone was taking their IRA required minimum distributions and they died after the required beginning date. Now, the Secure Act gives us some guidance there, and they say the following. So number one, if you forgot to take the beneficiary, if you didn't designate the beneficiary, but the participant was already taking distributions, then you get what's called ghost life expectancy. And they actually put that in the technical. So it's as if that person who died is still alive, right? And you're still on their plan, okay? As far as the life expectancy, you're under that table that shows if they were 80 years old, then they've got their distributions will go over their life expectancy of that uniform table, that we had there. So it's a ghost life expectancy. And you have to take the money out at least as rapidly at that time. So if you had a situation where there is a plan participant, the beneficiary is older than the plan participant, and the plan participant dies, you may have some hedging there. But generally, when you don't have a designated beneficiary, not a good situation, and the money's going to be coming out quicker, typically. Okay, so then, and I don't see many people, at least our clients, that don't have that, because we're really, vigilant on the funding. And this is another thing, like on the funding, they're not going to give you, on the IRA funding, they're not going to give you the beneficiary designation on your statements every month. They just don't do it. So when we ask for verifications, when Jenny and Taylor ask for verifications on the funding, it's we got to ask the financial advisor, or if you have online access, you have to give us the print of the beneficiary designation, because we're making sure it matches what our recommendation is. And I'll give you our standard recommendations when we go through. Okay, so that's non-designated beneficiary. This new category is the Secure Access. There's an eligible designated beneficiary category now. And they say, okay, well, what is that? So the eligible designated beneficiary category, these are people that get to use life expectancy treatment. And let me give you kind of the bad news, right? And I think most people know this. What the Secure Act did was they were tired of that situation where NAVA would be able to, a 7-year-old would be able to keep this IRA going for 77 years and just never, they're just getting huge tax deferral, and the IRS not getting their money. They're saying, non-spouse beneficiaries, typically, you got to pay that out in 10 years. Okay, that was the big deal there. So now, when we're looking at eligible, they said, no, not everybody. Eligible designated beneficiaries get to have life expectancy treatment. And these are the categories of the eligible designated beneficiaries. And we'll hit each one. You get a surviving spouse gets it, a minor child for a limited time, disabled, and those who are less than 10 years younger than the person who died. Okay. Well, let's look at the spouse, because the spouse has the most options. All right. When the spouse is designated as a beneficiary, the options are you can designate them individually as the beneficiary, and now you can also designate them where the spouse in a trust where the spouse is the sole beneficiary, or you can designate to a trust where the spouse and kids are both beneficiaries. So interesting there. Okay, and so let's just look at each one and how that works. Okay, and so the Secure Act 2.0 really kind of gave more options for the surviving spouse as far as beneficiary. And so this is all the code provisions right here, and the section 327A and section 327B of the legislation. And basically what it does, that's just, I'm showing you the technical provision. Basically, for those participants who died before December 31st, 2023, that's anyone who died this year before, right? And really this year, because those regulations came out last year, is that the surviving spouse, if they're the only beneficiary listed on the retirement plan, they had this weird loophole or thing where they could say they could wait until the plan participant's required beginning date to either choose between rolling over the IRA into their own IRA, or just leave the IRA in the deceased participant's name and take it as an inherited IRA. Now, there's a lot there to it. Let me explain how that works. And I think an example is the best. But that's just for a limited circumstance. So I'm not going to focus too much on that. I do have a client that happened to fit into that, and a lot of the stuff comes from that, is where the spouse died before the required beginning date. and they died this year, and they're kind of fall under this rule. But beginning January 1, 2024, enough comments were made that they realized their mistake. So they're gonna say that the plan, if the plan participant died before the required beginning date, the surviving spouse must be elected to treat as employee. So what does that mean? What is all that? I thought the best way to show that is in an example. Okay. And so, and it's all this terminology is key. Okay, so there we go. So we have my favorite cast of characters, Bill and Mary Sample, and usually I knock off the husbands first. I'm going to knock off Mary first in this one, okay? And her age is 60. Her age is 60 this year. She dies this year. Her date of birth is March 24th, 1963. And sorry, let me just make that lower. And her required beginning date, if she was born in 1963, right? Remember those other tables? I'll flash this up quickly. Okay. If she was born in 1963, right? Then her applicable age is 75. So what I do is, okay, she was born in 1963. She turns 75 in 2038. So her required beginning date is April 1st, following the year she hit that. And so that would be the required beginning date. And then the year that Mary reaches her applicable age, and I apologize for the technical, but this is the way it goes. And that's when she turns 75. It should be 2038. Sorry, that's a typo. Okay, so in my note, and you don't all have this. I'm happy to, a lot of the stuff I did after submitting it to Michelle, but we could definitely send these to you. Mary turns 75 on March 24th, 2038. Her required beginning date is April 1st of the year following that. Okay, and then Bill is older than her. Okay, so Bill's still alive, and his required beginning date. Remember, he's 54. Well, he was born in 1954. So we go here to this table. His required beginning date, or his applicable age, is 73. So then his required beginning date is the year April 1st of the year after he turns 73. That's April 1st, 2028. Okay, so what does all that mean? So let's say Mary dies, right? If Mary dies this year, this is what the new statute says. Bill can elect, okay, that's the surviving spouse, to wait until December 31st of, once again, of 2038. Okay, the year 2030, the year she reaches her applicable age, to make his mandatory first distribution. Okay, so think about that, right? Bill on his own IRA, right? When does he have to start taking the IRA distributions? April 1st of 2028 is when he has to take his first one. But in this, unfortunate situation, I'm just showing you how this works out. In this, if the plan participant dies before the required beginning date, then Bill doesn't need to take the distribution of Mary's IRA until 2038, until December 31st of 2038. All right. And then what table do they use? And this is where the Secure Act 2.0, they're going to have to give us some guidance. We think it's the single life table. Okay. So what happens is then Mary's going to go to this single life table, not Bill. Bill's going to go to this single life table, and he's age 70. So the divisor is 18.8, but he doesn't have to take it, right, until 2039. So we got to go to the age when he turns 2000 at that age, right? And then we're going to use the divisor at that point in time. Okay, I don't know how many years would that be? So if he's 70, it'd be 18 years. So he would be 88 before he'd have to take his first distribution. Okay. And then there would be a hefty, it would be a divisor at 6.6. And then he can come back to the table. Only the spouse can come back to the table each year. It's not like a subtract one. And you can see how they get better kind of treatment with regard to that. So that's this new law. That's with the spouse, they give him more options. Now, if he doesn't have to elect that, they get but that would not be bad if he didn't need the money, right? You can defer it for many years at that point. If he doesn't elect, then he likely will need to take distributions by December 31st of the year following death, 2024, and going to that single life table. You see the difference there? So spouse has options, is what I'm telling you, and the Secure Act 2.0 gave them these options, okay? And so that is the spouse situation. So we're looking at eligible designated beneficiaries, and that is for the spouse side of things. I'll kind of summarize that. And then if you did have someone that dies, there is this weird thing where they can actually even wait longer to even roll it over. But I'm not going to get into that technical aspect because it's only going to be valid till December 31st. And I'm not thinking everyone's going to run out. Okay, let me die. So January 1st, 2024, then that's where then it's where the plan participant dies before the required beginning date. I just talked to you about that. And that's what this is all means is in that example. Okay. All right. And then the law doesn't tell you exactly when you have to make this election. Is it that determination date that I told you about? That's September 30th, or is it December 31st? So they're cleaning up the legislation, but that's where we're at right now. And so this is another thing. They haven't put this in yet, but Congress ordered Treasury to amend the IRA regulations to allow the surviving spouse to use the uniform table. And the uniform table, I'm not trying to make a big deal of it, is much more forgiving than the other table. Because if you're an 88-year-old, you have 13.7 divisor versus the 6.6. So Bill may be able to use this table, okay? And this is all what they're talking about, but the law is there. They say you have to do the election. They're just not clear on when you do it. All right, so that's if you name the spouse as the individual beneficiary. And typically, that's our standard recommendation when you have married couples. For us, and there's we have these examples that I'd be happy to send these out. But typically, standard recommendation in a married couple situation, Bill and Mary sample, the primary beneficiary is going to be the spouse. Okay. Contingent beneficiary, a lot of times we want the trust, okay? And there's a lot of good reasons that I'll get into with regard to the trust. And maybe, in certain situations, in a trust situation, if you designate the spouse as the primary beneficiary, that's typical recommendation. But maybe in a second marriage situation where, if you designate the spouse as the beneficiary, they can roll over the IRA into their own IRA. And I forgot to say that part of it. This is if the spouse does not elect to roll over the IRA into their own IRA. Okay, the spouse always has that option. But if Bill, right, in that scenario, if Bill rolled over Mary's IRA into his own IRA, then he has to start taking distributions, right, by April 1st of 2028 if he rolled it over. But if he didn't elect to roll it over and elected to made the election to use Mary's applicable age or required beginning date, then he doesn't roll it over. In that situation, he probably wouldn't roll it over. That's what kind of made me sensitive to this in our client situation. That's what happened. It's like everyone just knee-jerk reaction just rolls it over to the spouse. Slow down now, okay? The surviving spouse, slow down. Talk to your advisors. Hopefully you have some advisors on here. There may be options, right, with regard to it. The spouse will roll over the knee-jerk reaction. Don't do it until you talk to somebody. Okay, that's why on our administration we have an initial settlement meeting, right, where we want to get everything organized. So don't go start moving stuff until we talk. Okay, there's definitely big issues at stake. Okay, so if you just designate a trust, right, as the beneficiary, why would we do that as a primary beneficiary? Second marriage situation where, hey, I want to leave my IRA to my spouse, but when she passes away or he passes away, I want the money to go to my kids from the prior marriage. Okay, if you just list the spouse as the beneficiary, they get to roll it into their own and they can do whatever they want. So maybe that situation you want to do that. Or maybe we're worried about creditors and we want the money in a trust for some reason, or we're worried about Medicaid. Okay, so it just depends on the client situation whether we want the trust to be there, right? And the protections that be there. And typically, trust protections are creditor protection. And creditors come in different forms, whether it's divorce, lawsuit creditors, or Medicaid, right? Remarriage protection, those issues, or second marriage situation. So just depends, right? So the new legislation really gave the surviving spouse. They even like just kind of put their rubber stamp. They stamp that, hey, trust planning with IRAs is okay. A lot of people before, they were really worried with having a trust as a beneficiary, and if the trusts are not drafted properly, that is a concern. Is where the IRS or the custodian will say, that trust is not a designated beneficiary. You're under those accelerated rules, right? But with those rules, and I was holding off on explaining that a trust can be a designated beneficiary. And so that these concepts of blue, yellow, green, hey, when I'm the plan participant, I'm on the uniform table, it's true blue, I can count on it. But when I die, right, and if I named a trust as a beneficiary, I say yellow because yellow means, if it's a yellow traffic light means slow down. We want to make sure the trust meets the test. And then green is, yep, once it meets the test, you get to have that life expectancy treatment that we discussed. And the test is not hard. Well, you just need to know what you're doing. So the trust has to be drafted properly. And the test, right, where the trust is an exception to being accelerated payout, and why we have it as a designated beneficiary, is the trust needs to be valid under state law. That means signed and in writing. Okay, if they can't meet that, then they're really where people get kind of messed up is on individual beneficiaries and identifiable beneficiaries. We'll talk about that. And then a copy of the trust delivered to the plan administrator. Show your work, right? And so they never look at it, but it's actually Halloween. It's coming up. So the October 31st of the year following the owner's death, we got to document. We got to show the custodian the document. They never review it. We have 70-page trust document. We put 4 pages to a page. We minimize it, put it on, just mail it, certified mail to them. Here you go, custodian. And then it's irrevocable on death, and all of ours are that way. Okay, and so our trust, just be assured it does meet that test. But this new Secure Act 2.0 said, okay, if we have the spouse as a beneficiary of a trust, and the spouse has to be, and they define 2 different types of trust: a conduit trust and an accumulation trust. A conduit trust is one of my teachers said, it's kind of like a plumber's elbow, where if money comes into that, if income is generated into the trust, all that income must be distributed out to the beneficiary. And the IRS says, hey, a conduit trust, we're really clear where the income goes because the trust says it must be paid out to. And if you say, if we have language in there that says, hey, if the spouse is the beneficiary of the trust, then it pays it out directly to the spouse, then the Secure Act 2.0 says, hey, the surviving spouse gets to use that uniform table potentially, and definitely the single life table, but gets to use the same treatment that they would have gotten if they were an individual beneficiary. The only thing that you give up in that scenario, okay, and that's where we have to look at the specific situations, right? You don't get to, if the surviving spouse is not the individual beneficiary, you don't get that election option, okay? If it's a trust for the benefit of the spouse, then you get to go to the probably the uniform table, but maybe the single life table, and money has to start coming out December 31st of the year following death, okay? But if you want to defer it to when the plan participant would have started taking distributions, you got to list the spouse as primary, and that's typically what we do. So that's the nuance there. And then they basically said that you can do this with a spouse with conduit trust, and a lot of clients that are in second marriages are worried about that. That's good to know. And most that situation where the spouse passed away before the required beginning date and before, that's a unique situation. It does happen. So, it's a counseling issue on this, but typically we're going to have the spouse listed as the primary beneficiary. But if the trust is drafted properly, we can have it go to a trust for the spouse, and you get pretty darn close results as well. Okay, that's the spouse. A lot of stuff on the spouse. The other eligible designated beneficiary categories that are out there, right? So we're talking about eligible designated beneficiaries. They get life expectancy treatment. We talked about the spouse. What about the minor child? So what about Nava, right? So Nava, she's 7 years old. What happens is they say a minor reaches the age of majority, and they being Congress, is when they turn 21. Okay, so Nava gets life expectancy treatment. She would go on the single life table, and so she would get life expectancy treatment until she was age 21. Okay, and so she would only go to the table once, 77.9, and then 76.9, 75, 74 each year. She'd have to take a little sliver of that out until she reached 21. Okay, once she reaches 21, the whole thing has to be taken out in 10 years. All right, after. So when by the age of 31 for a minor. Okay, horrible situation if that happens, but that's the rule. If you are disabled, okay, and that's a high standard, you have to be on Social Security Disability, SSDI, that level, then you can also get life expectancy treatment. And I typically find that those, they're older anyway, and so you may not be getting that much, but that's the situation. And they're usually using a lot of the funds to pay for medical care, right? And so it's not an issue of deferring it. Or chronically ill. This is when you can't do activities of daily living. You're in a nursing home, dementia, cognitive, those issues. Same issue there. And so they're giving you those, right? And then if you leave the money, if you leave your IRA to someone that's not more than 10 years younger than you. So my sister is 8 years older than me. If she left her IRA to me, which I wish she would, but she's got kids, right? Then I get to use my age. I'd go to the table once. I go to my age, 52. Can you believe it? And I go to a 34.3 divisor, and I just go to there once, and then 33, 32, 31. And so that's the eligible designated beneficiary categories. Okay. And that's okay. So we got that. And really the most clean on the eligible designated beneficiary is the spouse. Now, if you do have a disabled minor, child, there is a special trust we can do for that. It's beyond the scope for today. I didn't want to just blow people's minds, but that's good. Good question. Does Nava stay on RMDs from age 21 to 31, or can she stop at age 21 and deplete lump sum before 31? Great question. Great segue. Okay. So let me make sure people understand that question. That's a great question. I don't know who iPad 144 is, but good. So then let me show you what happens. Okay. So, hey, Mark. So then here we go. If Nava is age, so from when she gets to, does Nava stay on RMDs from age 21 to 31? Okay, so up till 21, she's on RMDs, right? Now we're trying to figure out from 21 to 31, the question is, does she get to wait till just lump sum it 10 years later, right? And just take it all in one bucket? Or does from 21 to 31, does she have to continue to take slivers of that IRA? And this is what the Secure Act did, okay? And this is why I love this chart. If I died, okay, after my required beginning date, right? So you go to my required beginning date, if I was taking distributions, right? If I died after that, then Nava has a 10-year rule, and she also has to, this is the new Secure Act rules, has to take the money out at least as rapidly as she would have had to take it out. So yes, she does have to take annual RMDs if I died after my required beginning date. If I died before my required beginning date, then you're under this category, and it all has to be out within 10 years. You don't have to take the minimum. You don't have to continue to take those minimum distributions. Did I answer your question, Mark? Okay, that's the big thing that's going on That's one of the things that caught a lot of people off guard, is that. And that's what this is. So if you're a plain old designated beneficiary, so remember, all this is like the terminology, and we're attorneys. You can have a non-designated beneficiary. We talked about that, right? You can have an eligible designated beneficiary. And now the plain old designated beneficiary is everyone else. And that's typically, the kids or non-spouse beneficiaries, unless you meet those small exceptions that we had gone through, or not those exceptions that we had gone through before, right? And so the plain old designated beneficiaries are under the 10-year rule, right? And this chart really kind of lays it out, all right? So plain old designated beneficiary, that's what Congress was going after. Hey, and really, it's typically spouse than kids, right, in most situations. And they just wanted to shorten that 10-year requirement. NAVA is an eligible designated beneficiary. You're right, okay, Mark. But if you look at, so we're going to go back. So we had minor child listed as a eligible designated beneficiary. She gets life expectancy treatment right here up till 21, right? And then from 21, she's a plain old designated beneficiary, okay? And she must take annual RMDs based on longer of the beneficiary's life expectancy, probably hers, right? Or ghost life expectancy, mine, until full distribution in year 10, okay? So it does apply. That's what the Secure Act is talking about, okay? That's the whole thing. So how does that least rapidly rule apply for death after the required? So if I died after my required beginning date, NAVA gets the IRA, right? She has to take the IRA life expectancy treatment up till 21. And then from 21 to 31, she's got to continue taking them. And at the end of year, right before the end of year 10, it's all got to be cleaned out at that point in time. So if you want to go into it deeper, we can separately, but that's what this whole Secure Act is talking about. Application of the at least as rapidly rule to inherited IRAs caught many off guard, okay? And so the Treasury waived the penalties. You're supposed to take those distributions. You were supposed to take, a lot of people didn't take those distributions. They thought, like, Mark was saying, hey, just wait till year 10 and then take it out. But they actually do, when it says ALAR here, that's after the required beginning date. They want you to start, you have to start taking it at least as rapidly at that point in time. And so that's what this notice came out just recently, said, hey, we know no one knew this, so we're waiving penalties for 2020, 21, 22, and for this year. So you don't have to do it this year either, okay? Probably next year, you should, if you have an inherited IRA and you fall into those categories, then you would have to take it at least as rapidly. So remember, this applies only to inherited IRAs subject to the 10-year rules, okay? And that means those people that had died after 2020. Okay, so let me show you our beneficiary designations options. I know this is kind of technical, but let's bring it back home. All right, so the beneficiary designation options. Typically what we do, married couple situation, okay, spouse is the primary, their trust is the contingent typically, and our trust has the language that has the ability to get designated beneficiary status. But again, when these regulations are finalized, and we're going to update Article 5 of our trust, typically has all of our IRA language that's in there. We're probably going to tweak that IRA language once they come up and give us final regulations and final guidance on it. Okay, so if you don't want a spousal rollover, right, or you don't want the spouse to be the primary beneficiary and have that election option, then you can have the primary beneficiary be the trust, right? Or if you're a single individual, right, and you want to have the beneficiaries, listed out there. Well, the single individual, I'll go. That's item 4. So if you're married situation, then you can have the trust as the primary, and we talked about that conduit trust. And then in that situation, you get more protections, or maybe in a maybe we're not worried about the taxes as much as the protections. or control, right? Second marriage, want to go back, or some type of creditor issue or like. And then we make the contingent beneficiary the spouse and or the kids in that situation. So the contingent beneficiary, if the spouse says, we look at all the options, the participant dies, we look at all the options, then we go to our D-Day charts and say, okay, we've got till September 30th of the year following death to figure out who we want as this beneficiary. And so if we talk to the spouse and we conclude, no, it makes a lot of sense for the spouse just to roll over that IRA into their own IRA, right? Then what happens is we do a disclaimer. The trustee of the trust disclaims it, which means it's a legal no thank you. The trust doesn't want it. It goes to the second beneficiary in line, who is listed as spouse and or kids, or a combination of both. Yeah, very good. Okay, so then so that's that situation. The third, and this is usually for smaller IRAs. Oh, and the reason why, this is usually for smaller IRAs in a married couple situation. We'll have primary beneficiary, spouse, and then kids. Okay, for that, there's not a lot there to protect. The reason why we typically will have okay, so let me keep going. So then the item 4 is, now we've got a surviving spouse or just a single individual, right? And they want IRA protection for the beneficiaries. So your options are, when you're single, right, or widowed, widower, is you can just give the IRA directly to the beneficiaries and list them individually, right? And what are the issues there? Certainly can be done. What's the exposure? Well, inherited IRAs do not get asset protection. Okay, at least it's not clear in all states. It's a lot of exposure. In Virginia, you definitely don't. And what that means is, like, for your own IRA, if you're the participant, every state has their own laws, and in Virginia and Maryland, there's certain, guys, about $1 million, $1.1 million, that your IRA is protected from creditors. Okay, but if it's an inherited IRA, that protection doesn't apply, and that IRA can be exposed, all right, to the creditors. So that's one issue. If we have larger IRAs, our clients are worried about that for the kids, divorce, creditors, those types of things. They like to leave it in the trust for their benefit, and they're not subject to that, accelerated payouts, because on the beneficiary designation, we typically we'll list it very specifically, right? And this is how we list the beneficiary designation, if we can, put it on their paper or attach a separate one. It's the separate trust share for Susan is the child there. And then the other one is Jack. These are the two kids. And so they get the full 10 years that you get now. So you get the maximum stretch out and you get the maximum protection. Or, like, in a situation where there's a minor child and you don't want, they can't inherit it directly, they can't manage it, you want a trustee managing the IRA for their benefit, that's when you do the trust in that situation as well. Creditor protection. A lot of times now, people are worried about Medicaid. Most of our clients are passing away, right? We live longer. Their kids are in their 50s, 60s, and they're worried about long-term care. And so if you get an IRA and it's in your own name in Virginia, that's a countable asset for Medicaid purposes. Again, this is beyond the scope, but these are the things that I'm looking out for our clients, right? Is like, people are just trying to do the easiest. You could, but what's your situation, and are you losing a lot of flexibility, and are you exposing the IRA, right, that you worked hard for? That's our job, is to protect that. And so these are the things that you do for that, right? And so that's the option. You don't have to do it, but that's why we do that after counseling our clients on those options, right? And then the contingent beneficiary could be the kids individually. We can, if the trust is worded properly, you're able to do that. So that's, today was the goal today was to go over. I know it's a lot of technical things, but I'm happy. This is our first shot at it. This sheet is very explains a lot if you can understand how this works, right? So if someone dies, right? If they die and they're not and let's say it's just a single individual, right? Typically, they're going to get, and we're not in a married couple situation. We know those married rules. Spouse gets the most options. But the first question I ask in my mind, if I ask the client, did they die before the required beginning date or did they die after the required beginning date? So once I look at the ages, right, and everything, and then I look at, did they have a designated beneficiary or a non-designated beneficiary, right? And so there you go at that. And this will tell you 10-year rule, if they died before the required beginning date and they're designated, if they died after their, then a 10-year rule, plus Secure Act 2.0, we're going to have you sprinkle out money until that 10 years comes out, right? We want you to do it. So we want some of our slivers of money. Non-designated beneficiary, not a good situation, especially if you die before the required beginning date. 5 years, all has to come out. And then you get more options if they died after the required beginning date. Okay. So, with that being said, I'm hopefully is not. Oh, here's some Secure Act quick facts handout. And the handout I gave you, I didn't like. We'll send you out a newer one. The one I gave you, unfortunately, cut off a lot of things. I got it from. It was a good summary. I got it from ADP. I got it from the web on the web from ADP. So this is. I'll just give a quick one. It's a nice PDF that you can use now. And I'm not, by no means am I endorsing ADP, just happened to be very easy on the Secure Act 2.0 changes, right? And so a lot of the changes are dealing with the employers. So if you're a business owner or employee people, or you're an employee, they're going to have to start. They want people to encourage people to start saving for their retirement. Okay, and so employers are required to automatically enroll employees in the 401k plan starting in 2025. You don't even have an option. Now, you do have an option to opt out, but the employees automatically are enrolled, and then the employees may opt out. Okay, and that's and they're automatically enrolling you, and they're deferring between 3 and 10%. They choose, unless you choose, but you can opt out. And then escalation of your contributions automatically, again, unless you opt out. But they want you to start saving at least 10% of your salary, because they're seeing, I guess, that Social Security and all these other things are not going to work for people. Catch-up contributions are people who are age 50 and older can contribute $7,500 annually catch-up to their 401k on top of the normal, contributions. And then it's going to go up to 10,000 in 2025. And so this is just, I'm not going to go through each one, some bullet points. They're giving you some ways, emergency saving ways to get money out if you're in emergency situations. Not much money, but they're giving you some more exceptions to take money out without getting that penalty, right? So if you take money out of your IRA before 59 and a half, you're penalized. These are they're giving us lawyers some more some more ways out. Not a lot of money out, but at least there's ways to do that. And then the RMDs, like we talked about, required minimum distributions, 73 in 2023, and then it goes to age 75 in 2033. I like that one little chart that I showed you. Really shows everything when you have to start taking it. So that's the those are some of the quick facts that are there. And let me see if there's anything else I wanted to cover for everybody. Nope, that was it. Any questions that you want to type in the chat that's out there, let me know. Or if you have questions, email me following up. But again, this is been the Secure Act for our clients, Secure Act 2.0 kind of summary. These IRA laws, I didn't make them up. I'm trying to interpret them for you. And so hopefully, if there are questions with that, give me specific questions and we'll make this better. And then I got someone commenting, Roth requirement for age 50 catch-up contributions starting in 2023 has been deferred. Watch this space. So like if you're making contributions, right, to your Roth, and like definitely talk to your financial advisors, right, first. Don't come to me first, and then we'll talk, to make sure that you're on the the right pace, because this is definitely an evolving field. I'm more focused on what happens after death, and making sure that we have all of your beneficiaries designated properly, and that why we're making these beneficiary designations. Okay. So, with that being said, I'm going to conclude the program. I'll hang out for another minute or so to see if there's any more questions that are typed in. But thank you, everyone. This has been Bobby Fazy, president of Insight Law, talking about the Secure Act and beneficiary designations and how they impact your retirement planning. Have a great day, everybody. All right, everyone. Have a great one.